All right, welcome back to the Judicial Proceedings Committee. Today is Thursday, February 15th, 2024. We're on voting list number 5. And we're going to start off with Senator Kelly, Senate Bill 42, and that's Josh.
Senate Bill 42 generally prohibits an adult who is present and directly supervising a minor from allowing the minor to ride a horse in specified areas unless the minor is wearing properly secured a helmet that meets or exceeds the standards of the American Society of Testing of Materials for protective headgear used in equestrian riding. So the House cross-file passed third reader today. It was amended in committee. And if you look in your packet, you will have the third reader version of the House cross-file. The amendments to that bill, you can see, are on page 3 of the bill. They kind of clarify the application of the bill a little bit.
The amendment. So the amendment really just clarifies that if you're doing a pony ride in a little circle, that the helmet requirement doesn't apply. So like at your 4-H pony rides. So I would like to adopt the House amendments. And I think, do we have to adopt the sponsor amendment too?
Do we have we done?
I came in with amendment on therapeutic helmets.
Oh, so let's do this amendment first, and then do you have the other amendment in the packet?
It's just conforming to the House.
Conforming to the House is fine because they have that amendment as well, which adds the therapeutic helmets. I talked about it in the hearing, and I'm sorry if you don't have it, but it creates the modifications necessary for children with disabilities who need special helmets. Yeah.
So Senator, yeah, it's House. If you go through your packet, it'll be House Bill 113. So it's a little bit farther down in the you have to go. I made that mistake too. Okay, so then council, just real quick, what would then the proper motion be to adopt the amendments that were made to the House bill? Is this all incorporated in amendment?
There isn't a separate amendment, and I think motion would be to conform to the House Bill 113.
Okay. I don't know if we could conform to something we were not in receipt of, but we can just do that. Okay. All right. So then the motion is to conform to House Bill 113.
And its current posture.
And its current posture.
Well,
that's my question. I don't know.
Because it's right in front of you.
I haven't seen it.
It's right here. It's 113.
It's House Bill 113. So this is. So you would literally just be adopting this version of the bill.
So if you want to look on page 3, that's the therapeutic language, line 15 to 19 on page 3 of the House bill. And then let me see where the minor. Yeah, and also line 6 where they add in therapeutic. It was clarifying. The purpose was to eliminate pony rides. But it actually appears as clarifying language somewhere in here. It's in a definition, I think. Let me see if I can find it. I believe it's whose primary purpose is equestrian activities. That language, I think, is what does it, because the primary purpose of the pony rides. I'm not positive. We can hold this and find out some clarity from. No, I know, but the point was at a 4-H fair or something like that. The primary purpose is not equestrian. The primary purpose was a community activity type thing. This. Oh my God.
So it's, I mean, as Senator Kelly explained, it's clarifying what facilities qualify under the bill. So on page 3, line, 3 and 4 there, it's interesting whose primary purpose is equestrian activity. So I wasn't involved in this drafting, but I assume the idea is if the primary purpose of the facility is something else and they just happen to be offering that day an equestrian activity, the bill would no longer apply to that situation.
All right. Yeah.
Purpose of looking into it.
in Frederick County, I know that there's a couple businesses that they actually go to people's birthday parties at the residence of the birthday, and they will offer like pony rides.
Private residences, she was taking care of Senator Jennings' earlier amendment that was in the original language of the bill. So that was worked out already, but we could, why don't you hold it? The only new language in this, aside from what was presented at the hearing, the therapeutic language was an amendment that was presented at the hearing. The other language, I know Delegate Hutchinson asked about this on the House floor, was related to the pony rides in a non, in a public fair or something like that. So take till the next voting session and take a look at it, and we can make sure to have any of your questions answered.
All right, Senator asked for hold, we'll hold it. So Jamie, you ready for Senate Bill 26?
Senate Bill 26 increases the maximum incarceration penalties for manslaughter by vehicle or vessel involving gross negligence. It increases it from its current maximum penalty of 10 years for a first conviction to instead be 20 years for that first conviction, and from 15 years for a subsequent conviction to instead be 30 years. There are no amendments in the voting packet.
I'll make a motion for favorable. All right. Is everyone okay being recorded in the affirmative? Yes, all right. Senate Bill 26 passes unanimously. We'll now move on to Senate Bill 46. Says Shamari.
Senate Bill 46 establishes that a contract for the sale of a condominium unit is unenforceable if the contract does not contain specified notices related to the presence of asbestos. There is an amendment in your packet. That amendment just replaces on the site with in the condominium. Essentially saying that the council of unit owners needs to notify the buyer if they have knowledge of the presence of asbestos in the condominium. It's just a language clarification.
Senator Sidner.
Just to be clear, you're, I guess on the site would have meant the entire thing, whereas this is focused for that particular unit.
Correct.
Thank you.
All right, so let's motions to adopt the amendment. All right, is everyone okay adopting the amendment? Now the bill's before you as amended. Further discussion? Motions for favorable with amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 46 with amendment passes unanimously. We'll now move on to Senate Bill 50.
Senate Bill 50 provides that a certain final order of the Commission on Civil Rights on a complaint alleging a discriminatory act is appealable in accordance with the Administrative Procedure Act.
I love this bill. Clean. Anything else?
No
All
amendments.
right, further discussion? Any discussion? Motions for favorable, it's been seconded. Oh, sure. We have a question from Senator Sidnor.
I just wanted to, the Civil Rights Commission, where did they come down on this?
They were favorable.
Okay, thank you.
That matters. I'll hop on this bill though. Can I make an amendment to hop on the bill?
Sure.
Does anyone else want to hop on the bill? Senator Carter, Senator Kelly, Senator Sidnor, Senator Muse, Senator Waldstreicher, Senator Charles.
Is there anybody that doesn't want to be on it?
It's a JPR committee bill.
There you go. All right. Senator, okay with that? Sponsor amendments? Okay, now the bills before you as amended. Motions for favorables and seconded. Is everyone okay with being recorded in the affirmative? Okay, Senate Bill 50 passes with amendment unanimously. Now we'll move on to Senate Bill 60.
Senate Bill 60 authorizes an out-of-state dealer of motorhomes or recreational trailers licensed by another state to display or exhibit but not execute a buyer's order or accept a deposit on motorhomes and RVs at vehicle shows for those vehicles in Worcester County specifically, and only in Worcester County.
No amendments, discussion? Motions are favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. All right, Senate Bill 60 passes unanimously. We'll now move on to Senate Bill 65, Senator James. Is that Josh, right? Is that Jamie? Sorry, Jamie.
Senate Bill 65 prohibits a person from violating the prohibitions relating to the knowing production, advertisement, solicitation, distribution, and possession with intent to distribute child pornography under criminal law 11207A4 or possession of child pornography under 11208B1 of the criminal article with either 100 or more images or any image depicting a minor or an identified individual indistinguishable from an actual minor younger than age 13. A person who violates either prohibition is guilty of a felony and on conviction is subject to a maximum penalty of 10 years in prison. As drafted, a sentence imposed for a violation of these prohibitions must be separate from and consecutive to and not concurrent with any other sentence imposed by the court for any crime based on the act establishing a violation of 11207 or 11208 of the criminal law article. As for amendments, there is a request to add Senator Kelly as a co-sponsor to the bill. There is also an amendment in your voting packet. It is Amendment 183-428/1. That is for Senate Bill 65, Amendment 183-428/1. The amendment makes the merger or whether or not the sentences run concurrently or consecutively discretionary on the sentencing court.
Yes. All right, we're gonna have states. Will live with the option. They just want to have that option. Thank you for asking, Senator Kelly.
It's a question about draft and if it can be done consecutively or concurrently, does that have to be expressed?
I'm not sure I follow.
If it, I'm wondering, I mean, I'm asking because I don't know, I'm trying to learn. If we take out consecutive to or concurrent with, and it just read straight the sentence, does that give the judge the option to go consecutive or concurrently, or does it have to be expressed?
Well, generally, it's more clear for courts if the legislature is more clear. I would have to, I haven't sort of done a merger analysis on this. I think under the rule of lenity, which basically says that where the same conduct is being prohibited and the legislature hasn't said one way or another whether the offenses are to be treated as one for sentencing purposes or separately, right? Then you would merge. Again, this is the first time I'm thinking of it for this particular bill. Okay. Then, I mean, under required evidence, like it's effectively the same evidence, at least for the 100 or more images. For the younger than 13, that's like an additional element. So you might actually have it under required evidence too. Or yeah. So my sense is like probably would end up being required to run concurrently if you said nothing. Right.
Okay. Thank you.
Okay, so the motion to adopt the amendment before you, it's been seconded. Is everyone okay? Now the bill's before you as amended.
Senator Kelly.
Yeah, that was in that amendment, wasn't it?
I mean, there's.
That's sponsor.
It's fine.
No, sorry.
Does anybody else want to be?
Does anyone else want to be on as a sponsor? Senator Waldstreicher, Senator Folden, Senator West, Senator Charles, Senator McKay, Senator Smith.
Who doesn't want to be on?
Everybody.
Does anybody not want to be on it? Everyone.
Channeling my inner Benson, Lottie Dolly and everybody. All right. All right. Yeah. All right, so now the bill's before you as amended. Further discussion? Motions for favorable with amendments? Second, is everyone okay being recorded in the affirmative? Second, excellent. Good work, Senator James. I would say, just for further discussion, some of us were talking about this earlier today. We'll have another bill that will touch on this, but for, the instance of like deep fakes where you have someone that it is your actual face, but you're in compromising positions with other people and those are populated throughout the internet, we should probably take a look at what we can do that, I'm sure I'd like to have something like the ACLU kind of weigh in about the, free speech and all that other stuff too. They're kind of counterbalancing issues there, but we should look at that. And I think we'll have a hearing that touches on that. I think next week or the week after that, but just to plant the seed. Okay. So now we'll move on to Senate Bill 92.
Senate Bill 92 requires a place of public accommodation that is a motion picture house to provide access to fully operational and well-maintained closed captioning technology for the general public for each screening of a motion picture that is produced and offered with closed captioning. It requires that a place of public accommodation that controls, operates, owns, or leases at least 2 motion picture houses in the state to provide open captioning for each motion picture it screens each week for at least 2 screenings each week. This requirement does not apply during the first 7 days after a motion picture premieres in the motion picture house. So there is an amendment in your packets. That amendment adds a definition for closed movie captioning. It deletes the provision that doesn't require movie houses to have open captioning during the first 7 days of the movie opening and replaces it with a requirement that with a requirement that they do not have to provide open captioning for movies that are screened fewer than 5 times in a 7-day period. It requires open captioning only in the first 3 weeks of a movie premiere. It requires open captioning at movie houses with 8 or more screens for at least 2 screenings per motion picture per week. And it adds a provision that after the first 3 weeks, a place of accommodation may provide open captioning with reasonable notice.
So before we, I know this is an amendment that is before us, but well, not really before us, but it's been submitted before the committee. But we did do some work on this, and I thought that we were close to a kumbaya moment where kind of all parties agreed, and that did not mature. So that didn't happen. So we did talk about some ideas. I don't know if anyone wants, but we did get a kind of a smaller work group. If anyone wants to talk about some of the ideas that we put forward, just for consideration. We're probably going to hold this bill, but go. If you want to go ahead, Senator Folden.
So I'm going to apologize because I missed the one part where they were talking about the number of days. And was it what we discussed?
This was the sponsor amendments.
Okay, so one of the things I thought that we were trying to discuss, and I think we're obviously agree that we're gonna have to hold it so that people can have an idea of absorbing any of these changes, but was that most movies are released on a Thursday, Friday timeframe, that we would have this, they would still have other available ADA compliant options available, but the first 10 days of any premiere or release would be this standard or this rule would not apply. And then beyond that, it would be for 2 showings each week per show. So, and I thought that was a pretty reasonable understanding. And I don't know that I've heard anything to the contrary, but
no, I thought so as well. I mean, we'll let this sink in we'll vote on it next week or something, but I actually liked what we came up with, but Senator, sorry, yeah, there are a couple other elements to it. Do you have those? So the advocates for the bill to be honest with you, I haven't run it by them. I didn't, but because we just came up with the idea yesterday.
Yeah.
Shamar, can you remind us what the other elements were, just so we can
Get the sponsor amendments or what we
talked about?
Okay, so it would change the requirement for not requiring open captioning for movies shown fewer than 5 times in a 7-day period, and instead just make it so open captioning is required after the first 10 days for 2 showings per week. with no time period. So after the first 10 days, open captioning required 2 screenings per movie per week.
And this only applies to if you have two or more locations, and if those locations have 8 screens or more. Is that right?
Well, under the bill, originally, it was only applying to motion picture houses, to operators that had more than 2 locations. Under the amendment, it only applies to operators, motion pictures with 8 screens. And so that would encompass the very large companies. I don't think there was agreement as to whether it should be more than 2 picture houses or the theaters with more than 8 or more screens.
So just to recap it from the top, it would be, I thought it was 2 more, but whatever. Let's say it's 8 screens or more. You have the first 10 days, you're not required to have this open captioning. After that, you have to have it in at least 2 showings a week for as long as you have that particular film showing in your movie house. That was the proposal that we came up. We have not run it by the advocates or No.
But the 10-day thing, was that in the first original bill?
No, we just came up with that because Senator Bolden said it's like it gives you, when you have a premiere, like the where they make the most money. This is when the movie's new, and so now a lot of folks have been opening up on Thursdays to capture more money, and so that gives them the first 2 weekends of a premiere weekends to make the lion's share of their money before this new requirement is put in place. That's the idea.
Well, go ahead.
Get a vote on it.
Yeah,
Just like the whole thing.
So
Let's
do this.
I kind of want to ask the question. Do we all believe that the open captioning, even in one of the theaters, or one of the, rooms that shows the film, would actually inhibit their profits? Or is it just an impracticability?
So I'm sorry. Last year, we heard testimony that with open captioning, there's other moviegoers that wouldn't want to have it embedded in the picture. Whereas with closed captioning, which is available in just about every movie, you have the personal device, at your seat where you can watch the captioning without inhibiting other viewers' experience.
We should think about it, talk about it a little bit more.
Yeah.
I like to actually know from the advocates who actually are impacted.
Yeah.
How they feel.
Yeah. We could Senator West, go ahead.
I'm trying to read the amendment, and down lines.
Just to be clear, we were talking about not that amendment. We were not talking about that.
Oh,
amendment.
we're talking about different.
We were talking about one. Yeah, just to be clear. Sorry.
Yeah. Sorry.
Yeah, no worries. Yeah, let's hold the bill.
It's and proponents come in.
Yeah. So how about this? We'll do another work group. We'll bring advocates both
Perfect.
sides in, and then can we just do like a 1-pager of what we just,
Yes.
the sponsors amendment, but then also the amendments we talked about. We could bring them in together. We'll come back next week. Okay. Senate Bill 92 held. Now we're on for Senate Bill 111, and it's Jamie.
Senate Bill 111 requires a party or non-party making an electronic or paper court filing, which also includes under the bill a filing of a charging document in a criminal or juvenile delinquency case to redact any identifying information, which is a defined term in the bill, that appears in the filing unless the court finds by clear and convincing evidence that there is good cause to order otherwise. The bill provides that the Supreme Court of Maryland may also adopt rules requiring or authorizing a person making a redacted filing to also file an unredacted copy under seal. Under the bill, identifying information means the name of and any other information that could reasonably be expected to identify a minor victim. There is one amendment in your voting packet from Senator Sidnor. It is Amendment 323-620/1. That's SB 111, Amendment number 323-620/1. The amendment provides, strikes provisions of the bill and provides instead that the court or a party in a criminal or juvenile delinquency case may not disclose or allow inspection of a court filing in the case to a non-party unless all identifying information of any minor victim is redacted. Let me just pull up the specific language in front of me, and I'll read it back to you as it appears in the bill. So if you look at the reprint on bill page 2 of 2, down below line 12, starting at line 7, and then there's stricken language. Notwithstanding any other law, unless the court finds by clear and convincing evidence that there is good cause to order otherwise, the court or party in a criminal or juvenile delinquency case may not disclose or allow inspection of an electronic or paper court filing, including a charging document, to a non-party to the criminal or juvenile delinquency case unless the court or the party disclosing or allowing inspection of the filing redacts all identifying information that appears in the filing. And again, identifying information would keep its defined term under the bill. That's if you're looking at the reprint starting at line 1 in page 2, identifying information means the name of and any other information that could reasonably be expected to identify a minor victim. And I just noticed, oh, never mind. I thought that there was a typo there, but there's not.
Thanks. Just for clarity, the bill in its original form and the amendment only pertain to non-parties, correct?
Right.
So no party would be precluded from being able to identify.
Right. So there was some concern, I think, raised at the bill hearing about whether or not this would impact discovery, access by defense counsel and the defendant to the full unredacted records. So this was designed to just pertain to disclosure to non-parties. If you're a party in the case, there's no requirement for redaction.
Senator.
I'm looking at the amendment, subparagraph 2. Why are we including the word a criminal case in here? Does this affect all criminal cases in the state of Maryland?
Right. So if there is identifying information for a minor victim, and I think maybe it requires looking at the definition to figure out what identifying information is pertaining to, because we don't actually use the word minor victim in the that paragraph 2 language. If you look just above that, identifying information, and this may be too limiting of a definition,
But
because it seems
you've
like it's
eliminated
broader.
the words identifying information from subparagraph 2.
Subparagraph
You
2.
read it in its entirety as rewritten. Unless the court finds by clear and convincing evidence there's good cause to order otherwise, the court or a party in a criminal case may not disclose or allow inspection of an electronic paper court filing to a non-party to the criminal case. There's nothing about identifying information.
Right. If you keep looking, Senator, unless the court or the party disclosing or allowing inspection of the filing redacts all identifying information. So it's.
I didn't get down to the very end of it. Okay.
Right.
And identifying information is the name of minors. Okay, minor victims. Got it. Okay.
Other information that
So-
would be expected to identify them.
Right.
So black tattoo under left eye. I don't know that is what it means, because that's very general. It could be anybody, but.
All right, well, let's move the amendment. Is everyone okay adopting the amendment? All right. Now the bill's before you as amended. Further discussion? Motions for a favorable, it's been seconded. Do we need a roll call, or is everyone okay being recorded in the affirmative? All right, it's good. Good. All right. Senate Bill 111 as amended passes unanimously. We'll now move on to Senate Bill 113.
Senate Bill 113 expands the existing crime of sexual solicitation of a minor under criminal law 3-324 by prohibiting a person from committing the crime of sexual solicitation of a minor with intent to commit a violation of the existing prohibition against the production or distribution of child pornography under criminal law 11-207. Under the bill, violators are subject to the existing penalties of for sexual solicitation of a minor, which is currently a felony punishable by for a first offense up to 10 years and a fine of up to $25,000, and for a second offense or subsequent offense, imprisonment for up to 20 years and or a fine of up to $50,000. There, as far as amendments, there is a request to add Senator James as a sponsor to the bill.
For the committee, if it's okay.
Yes, of course.
So this is the bill that sounds a lot more complicated than it is from the hearing. This is the one where they want to make sure that the undercover officers can be prosecuted. So we're just referencing one existing law in the section of another existing law. It's not increasing any penalties, not creating any new crime. So just wanted to make sure everyone remembered that. And I would like to move, well, I guess we need to move the amendment, and then I would like to move the bill.
Yeah, wait, so there is, just being clear, the amendment is a sponsor amendment. Yeah, so does anyone, do we all want to be on, or does that, okay, I think the entire committee wants to jump on, so. So okay, adopting the amendment. All right, now the bill is before you as amended. Motions for favorable with amendment. All right, seconded. Is everyone okay being recorded? All right, Senate Bill 113 as amended passes unanimously. We'll now move on to Senate Bill 125.
Senate Bill 125 requires the seller of any residential property located within a half mile of a national priorities list Superfund site to provide a specified addendum to the contract of sale. The addendum must include the identification of the Superfund site that is within a half mile of the property, the definition of an NPL Superfund site under U.S. Environmental Protection Agency guidelines, information regarding specific EPA websites, and a notice that within 5 days after signing and dating the contract, the buyer may void the contract and on rescission receive a full refund of any money paid to the seller. There is an amendment in your packet. The amendment increases the distance which the addendum is required to 1 mile instead of a half mile. It also deletes provisions within the statutory addendum, deletes the incorporation provisions, and as well the provision in the beginning of the addendum where the buyer has to list their name and date the addendum.
So I know there's a lot of discussion and debate on this. There was a work group that came back with some recommendations. So can we just, setting the amendment aside, I'd like to have just a little bit of discussion. Probably gonna hold this because I don't think there's strong consensus just yet, but the folks that were on the work group, do you want to give us kind of like a little bit of a report out just so the rest of the members can hear?
So I can just report, the work group pretty much agreed to strip the bill entirely and just add a notice similar to that's provided with lead asbestos. The amendment is kind of a middle ground. It's makes the addendum language less strong, but it still requires a signature by the buyer and the seller.
The question is for Senator Folden. When didn't you have a conversation?
I did.
So do you want to share that conversation?
Look, I mean, at this point, the longer we wait, the more people are just going to be, they're going to be building on top of these areas. And it's really more, for me, it was about that because the number of homes have gone up in these immediate areas in the past year that really people should have been notified and they're not. So they've come to a middle ground on this, I believe, on the amendment, and that
I think the realtors were okay with it, right?
That's my understanding, but I mean, I know there's another amendment that came up just about being like from 0.5 miles to 1 mile now.
That,
So I don't, like, there keeps being things added in to muddy this up.
the work group liked the idea of the realtors amendment.
Of signing, they like that, but then I guess they want still, the advocates would like an actual signature stating that they were advised of such
Right.
proximity.
So I can clear it because I know that, so, yeah, I mean, and then also, I mean, I know that some people were having discussions of like how like these Superfund sites can from time to time get expand and contract in size. So it's hard to do like a definitive line of, you know, is it 1 mile or half mile or whatever it is. Also, look, like, if you just slide it in with, you know, when you sign a mortgage, I mean, you go to close on a house, the stack of paperwork is like this high. And so sliding another one in, that's great. At least you have notice, but it doesn't say that you're close to one. It just says, hey, you may be next to a Superfund site, and it doesn't tell you how far away or how close it is. There are also elements of like just blighted areas and underdeveloped areas that curtail development.
And that's my concern.
Yeah, yeah.
In the county where I've got one.
So it's a much more complicated issue. And I know that folks would like an addendum that you'd have to sign, and that gives that clear notice. But then again, we get back to the point of like, well, where is the line? So I think we're going to continue to work on this. I'll just hold it, but I just wanted to put it on record as some of the
Maybe we can
discussion.
Get back with the realtors. Would they be okay with the signature? Because if they're already signing, no.
I had received contact from the sponsor
Right.
that they were working with the realtors, and this was the amendment I received. I can't speak to whether everyone agreed, but
My understanding, asked for the 1 mile. For the expansion. Up to, yeah.
I know this is a tough thing to, this is a tough conversation to have.
They don't know what they're talking about. I'm just kidding.
It's a tough conversation now because you got constituents that are living in these areas, but you want to protect them, but you also understand that you want to encourage development in areas and make sure that you're doing this in a more a manner that actually makes sense.
Right.
So I get it.
There is an option. To make it a county by county rule. So that would probably take care of Senator, not to speak on behalf of her.
I was involved with some discussions in a work group where we went in one direction. So this is new to me. I have to read it. That's all I'll say. That's all I'll say for now.
Yeah, fair enough. No, I mean, this is, you know, yeah, I got the work group recommended. That's why I wanted to have this discuss, just lay
I
that out there,
appreciate
that this is one
Right.
set, here's
appreciate
it, and then we're going to continue to have the discussion and
Thank you.
yeah,
Because my only last 2 cents is that I think we ought to go with what the work group had come up with. Because I think the work group came up with something that took everyone in consideration. And I think that's the best plan.
that's typically my feeling on the thing. You had
Well, that's
3 senators on here to move forward with something and do a deep dive. So
so
that's,
the
yeah.
agreement,
back. We'll go
Mr. Chairman, the agreement was like the work group that was put forward in Castelli and all those, like, they're all okay with it. And the people that were the advocates on behalf of this are all okay with the work group product.
I only have the sponsor amendments.
So then
I can,
I think the committee work group.
got it. The committee work group product, you just put it in as a chair amendment and we'll have it for the next voting session. Okay. All right. So then when you go, now we'll move on to Senate Bill 130.
Senate Bill 130 establishes a new offense prohibiting a person from committing indecent exposure with prurient intent when the person knows or reasonably should know that a minor is present and the minor is at least 2 years old and more than 4 years younger than the perpetrator. This offense is a misdemeanor and is punishable by imprisonment for up to 5 years and or a fine of up to $10,000. The bill also codifies the existing prohibition on committing the common law crime of indecent exposure. A violator is guilty of a misdemeanor and subject to the existing statutory penalty of imprisonment for up to 3 years and or a fine of up to $1,000. There are no amendments in your voting packet.
We pass this unanimously. Further discussion? Checking, I know we passed this bill last year, but
It was Senate Bill 208 last year and JPR did pass, the Senate passed it.
all right, Senator Carter.
Did I vote for it? Okay, I must have been throwing one there. So I'm not trying to influence anybody as to how to vote because indecent exposure is pretty disgusting. I remember being a teenager on a subway in Baltimore, and it happened to me, and it was to this day, I'm not recovered. It's horrible, horrifying. But I believe the person that did it was probably homeless, not an excuse, and was just all, terrible looking, unkempt. And it was traumatizing. And certainly the person doing it though, probably had no idea what my age was, probably did it all the time, to whenever he could, because it's some kind of impulse control issue a lot of times, not all the time. And I think that there have been some concerns raised by other people about this idea of in front of a minor, where there could be some familial issues or where it may not really be the intention, but a minor is in the presence. So I'm just gonna state my piece that I don't think on principle it is a bill that makes logical sense, but I understand people's feeling about anything that happens in front of a minor. I mean, technically in that situation that I recall all of these years later and still feel traumatized by, it did have a lasting imprint, but at the end of the day, the person would have no sentence because nothing happened, which I think is the most of the time that nothing happens, because it's usually like you're walking down the street and someone flashes by you or something like that, or that situation like a subway where you're so stunned when it happens that you can't even make any move. I was more stunned that people around me on the subway didn't have any response than at the actual person that did it. So I'm saying all of that to say, if it's just that we want to say we cracked down on this awful and vile behavior in front of a minor, fine, that's we can do, but it really doesn't do anything to address the problem or the situation. It's not going to stop or prohibit or prevent anybody that has that impulse to do it. And more often than not, they're not, the way that this bill is structured, it's not such that, or maybe it is, Jamie, it doesn't seem that it's that they had to know that the minor was present or specifically be doing it to the minor. Literally, it could be like they're in the house with a bunch of people and the minor just happens to be in there and walks in at the time, correct?
Right, so
No, you have intent to
Prurient
commit the indecent exposure, but to do it in front of a minor.
So I think you could have prurient intent, which is basically intent for sexual gratification. But it indecent exposure when the person knows or reasonably should know that a minor is present and the minor is. So it reasonable, whether, I guess if they didn't actually know, but the circumstances were such that they should have, then
Like any open park, it's reasonable to believe that a minor could be present. It's, but my point is that somebody's gonna do an indecent exposure in or stalk through a streak through a park. I don't know. I'm not arguing anything. I just think it's another example of how we take a problem and we want to protect children, but I don't know that the enhanced 2-year sentence that probably isn't going to be imposed in most cases anyway, is a real solution. It's just a feel good, oh, we did something kind of thing, I think.
Senator West.
I just was going to call everybody's attention to the fact that part of the crime is with prurient intent. So,
You know, just like a lot of men, you don't listen when a woman already makes the point. But I already went over that, Senator Rose, but I
Sorry.
appreciate that you were, like my husband, paying attention about every twice.
Happy Valentine's Day.
That was just off the, it's not off the record, but I appreciate that you and I saw the same thing. That's a better way to say it. I'm so glad you saw that, Senator Rose. Thank you.
Thank you. It's getting a little spicy in here tonight. No, I know. All right. Oh, man, he's beat red over there. It's great. All right. Thank you. Please pray. All right. So with that. Yeah, that's great. All right, so then now all right, now the bill is before you with no amendments, motions for favorable. Seconded, do we need a roll call or is everyone okay being recorded in the affirmative? Okay. I'm sorry, yes, you can. Let's do, so sorry about that. We do sponsor amendments, Senator James, Senator Folden, Senator West, Senator McKay.
We have James, Folden, West, and McKay.
Excellent, okay. Now the bill's before you as amended. Motions for favorable and seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 130 passes with amendment unanimously. All right, now we're gonna move on to Senate Bill 132. That's Josh.
Senate Bill 132 repeals provisions related to gubernatorial approval of a decision by the Parole Commission to grant medical parole to an incarcerated individual serving a term of life imprisonment.
Motions for favorable has been seconded. All right, is everyone okay being recorded in the affirmative? Yes. Senate Bill 132 passes unanimously. All right, that was a great bill. Senate Bill, we'll now move on to Senate Bill 171.
Senate Bill 171 requires a landlord to accept financial assistance from the Office of Home Energy Programs within the Department of Human Services for the cost of utility services that a tenant is required to pay. A landlord must provide a tenant on request with utility service documentation necessary for the Office of Home Energy Programs to determine the tenant's eligibility for financial assistance as specified. The bill authorizes imposition of an administrative penalty for noncompliance. Penalty revenues accrue to the general fund. There is an amendment in your packets. This is a sponsor amendment. It strikes the body of the bill. It requires a landlord who requires the payment of gas and electric utilities to the landlord to give notice in a written lease and either provide a copy of the gas or electric bill or before the beginning of the lease and each term that thereafter notify the tenant in writing of the total utility costs. The amendment also makes the bill's new provisions inapplicable to a ratio billing system under 8-12.4. And a ratio billing system is a system where utility usage isn't measured per tenant. That section of the code provides for how the landlord notifies the tenant of their utility bills.
For discussion on the amendment. All right, you're good. Oh, you're fine. All right. Got it. All right. I just, because I know you had, it was a good discussion. I mean, it was really good discussion. Yeah. Sure. Yeah. So yeah, Senator Folden.
So what I heard you say was the concern that we had about the multi-unit for a single billing source. Is that right? Corrects that? Perfect. Thank you.
But it was a really good discussion last time. That's all.
So you did a great job.
Excellent. All right.
Sure.
So let's adopt the amendments. Is everyone okay adopting the amendment? All right. There's been a motion to move the bill with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 171 passes with amendment unanimously. We'll now move on to Senate Bill 182.
Senate Bill 182 establishes requirements, procedures, and prohibitions to govern the use of facial recognition technology by law enforcement agencies. It also, with certain exceptions, prohibits the introduction of results generated by facial recognition technology in criminal and juvenile delinquency proceedings.
All right, now bills before you, it's just discussion. All right. Yeah. Motions for favorable and seconded. Sorry, I'm sorry. Oh, wait. Hold on. All right, look, we passed this bill unanimously last year. But since it's got a little bit of a fiscal note, I have to check with the B&T committee, get a letter, get approval. Just to be clear, what is the threshold line for us? $250,000 we can do without. Okay, I will make sure I do that. Okay. So can you just please make a note to do it like today?
It's in their system.
Oh, it is in their system.
We're just waiting on them to get back to us.
Okay, so we've already made the request. We're just waiting for them to get back. I will talk to the chairman today, though. Okay, all right. All right. All right, so we have to hold Senate Bill 182 pending feedback from B&T. We'll now go to Senate Bill 187.
Senate Bill 187 repeals the authority of the Division of Corrections to arrange for the employment of inmates in agricultural work at specified camps. The Department of Public Safety and Correctional Services has advised that no such camps exist in the state.
Motion for favorable and seconded. Is everyone okay being recorded in the affirmative? Excellent. Good bill. 187. Senate Bill 187 passes unanimously. We'll now go on to Senate Bill 190.
Senate Bill 190 requires a law enforcement agency that receives a qualified request, which is a defined term under the bill, a qualified request for a wellness check of an individual to immediately conduct a wellness check of the individual if the individual is located in the law enforcement agency's jurisdiction, or submit a request to the relevant law enforcement agency in the state or another state to conduct a wellness check if the individual is not located in the law enforcement agency's jurisdiction. A law enforcement agency that receives a qualified request must meet these requirements regardless of where the individual or entity making the qualified request is located. And a qualified request under the bill means a verbal or written request that includes sufficient information regarding a specific life-threatening concern for immediate action or response. There is a request from Senator Muse's office to add Gabriel's Law to the short title of the bill.
Okay. I know the so sponsors got another amendment that's working out. I know the work group worked on this, it had several concerns. We're trying to figure things out. So we're going to hold the bill and we'll come back at a later date. So we'll hold off on adopting that amendment too until we get all the stuff straight. All right. So Senate Bill 190 held. Then we'll go for Shamari with Senate Bill 199.
Senate Bill 199 authorizes a condominium regime to be established on certain land owned by an affordable housing land trust. There are no amendments.
There's a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 199 passes unanimously. All right, we're now going to go to Senate Bill 260.
Senate Bill 260 is a departmental bill that alters the definition of earned compliance credit to exclude specified monthly supervision fees in order to allow an individual under the supervision of the Division of Parole and Probation to accrue earned compliance credit to reduce their period of supervision without the individual necessarily being current on the payment of those supervision fees, which are $50 a month.
Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 260 passes unanimously. We'll now move on to Senate Bill 277.
Senate Bill 277 is a departmental bill that exempts certain applicants for ID cards who present appropriate documentation to the MVA from paying the required fee. The bill also extends the terms of learners instructional permits from 180 days to 1 year. And finally, the bill establishes that a driver's license issued to certain government contractors and dependents must remain in full force and effect during an absence from the state if specified criteria are met. There is an amendment in your packet. It's number 853228/1. So in regards to the fee waiver for ID cards, the amendment removes sort of a catch-all provision which allows the MVA to establish additional criteria for fee exemptions.
Yeah, that confused me earlier. All right, motions to adopt the amendment. Is everyone okay adopting? All right, now the bill's before you as amended. Further discussion. There's been a motion for a favorable with amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 277 with amendment passes unanimously. All right, we are going to move on now to Senate Bill 282. Everyone here likes the bill, but we're having further discussions about the funds. We're going to hold this bill until we get some more information from budget and tax. We'll now move on. Sorry, you want to say something?
No, I was just going to tell you.
Okay. So for Senate Bill 287, we're also still waiting for forthcoming amendments from the House. And so we're going to hold off on that. I think the department's working with them on that side. Okay. So we've held Senate Bill 282 and we've held Senate Bill 287. We're now going to move on to Senate Bill 373. Say what the bill does and say you're still moving on.
Sure. So Senate Bill 373 generally prohibits the knowing and willful theft of mail or an arrow key or other device used to gain access to a mail depository. The bill also establishes graduated penalties based on the number of intended recipients for stolen mail, the type of information contained in the mail stolen, or the status of the intended recipient of the mail stolen as an elderly person or disabled person.
Can you give a little bit of the history of the statute that we're looking at, or do you want to just talk about, just say, I know you're working with the vice chair, if you want to say anything, but.
So there is an existing statute under the criminal article that prohibits the taking and breaking of somebody else's a letter from another person. That carries, I believe it's 15 days in jail and nominal monetary penalty, but the statute actually originates from before Maryland was actually a state, so before the revolution. So it's a pretty old statute.
Talk about how the old laws supported in. Give the history, man. This is fun.
But I guess
I'm asking him for a little TED talk here because this is really fun. This is actually good history. So
yeah, one of the
drop some
things
knowledge,
that came up in the research for this was well, obviously the question was when Maryland became a state, you know, what happened to the laws that that preceded that, because the General Assembly obviously existed before the Revolution. So the laws that Maryland had continued to be the laws that Maryland had. It's just, you know, we had a new status as a state.
And they ported into the code.
Eventually, yeah.
Yeah, that's fine. That $15 fee predates the 7th state. It's pretty cool. Anyway, all right. So we're still working on amendments. We're close. Okay. So that means we're going to hold Senate Bill 373. We're now going to move on to Senate Bill 380.
Senate Bill 380 establishes a police recruitment and retention work group. The purposes of the work group are to, one, identify and examine issues and factors potentially contributing to recruitment challenges and the decline in police officer retention statewide. Two, explore recruitment and retention strategies used successfully in other states and countries. Three, design a statewide joint apprenticeship and training council, including multiple departments and unions to operate a police registered apprenticeship beginning in high school. And four, provide recommendations for reviewing the decline of police retention statewide. The Department of State Police must provide staff for the work group. The work group has standard boilerplate language that work groups do. There are no amendments in your voting packet. However, I did want to note that the committee has amended a number of task force bills. So I just wanted to flag that for the committee.
Do you want to offer that? Go ahead, Senator West.
Walt Stryker amendment to task forces that I reported on the floor this morning about, that whoever appoints someone to the task force
They
can
serve
remove
at
that person.
the pleasure of the appointing person.
Yeah.
Right.
This, by the way, we passed this bill unanimously last year. So.
And it'll also have the other language about code of conduct.
All right, so I was making sure. All right, so let's adopt the work group language first. Is everyone okay adopting that amendment? All right, I'd also like to be added onto the bill. So sponsor, is everyone okay with that? And then we did, West, there was one group that wanted to be off of the bill last year. I don't see them on the bill, so this is basically as amended.
Was what group last year that wanted off the bill? Is there another one this year that wants off the bill? It's still off, yeah. I think it was the NAACP. Was the ACLU? Oh, you're right. You're exactly right.
But the amendment that you, when you read the amendment, you mentioned, the recruitment efforts, from high schools and the like, because I don't see it in the original bill. Is that an amendment?
No, that's let me just pull that up.
But it's the language is there and one or the other.
Right. So if you're at the bottom of page 3, it has the four requirements. So in subsection G of the bill, and
Okay.
that's in G2. So design a statewide joint apprenticeship training council, including multiple departments and unions to operate a police registered apprenticeship beginning in high school. Is that?
Yeah.
Yes. Thank you.
Okay. Uh-huh.
Now the bill before you as amended, motion is for favorable with amendments. It's been seconded. Do we need a roll call or is everyone okay being recorded in the affirmative? All right. Senate Bill 380 as amended passes unanimously. We're now going to go on to Senate Bill 391.
Senate Bill 391
Okay, got it.
establishes that an individual may be prosecuted at any time for a violation of the following sections of the criminal law article: sextortion under 3-709, stalking under 3-802, and revenge porn under 3-809. There are no amendments in your voting packet.
So it says, I know that generally, and counsel, you correct me if I'm wrong, but generally misdemeanors have statute of limitations of 1 year. There are some that I learned about, throughout looking at this bill, like, misconduct in office is 2 years, and there's some random ones that are 3 years. There are 26 misdemeanors that have no statute of limitations, and from what I can tell, there's no through line. They're just kind of random. So everything from using of forged or falsified counterfeit signatures to bribery of a juror are all misdemeanors with no statute of limitations. So there's no connection. There's no through line with all those 26. There's no theme or anything, and it just so I guess to that extent. I mean, I know to me, I talked to some folks and got a lot of good information. There's one other person I want to talk to before I'm comfortable voting on this. But I talked to one that helped me a lot. But because initially, remember in the hearing, I said, okay, for revenge, for the porn that's online, that is there forever, and I get it for statute of limitation. But for stalking and for sextortion, I had a more difficult time kind of understanding. And so I still want to talk to one other person to help me with that, but I would like to open it up to discussion if people want to talk about it, but I'd like to hold the bill for just into the next voting session.
Thank you. Yeah, thank you, Mr. Chairman. I actually had a similar conversation with Senator Carter. I think she wanted some time to look at the bill as well. So I think it's wonderful to give folks another week to look at the bill and talk to folks and get their questions answered. I think we're going to get there on this bill, but I want to make sure everybody is comfortable, and we've had all those conversations. So thank you.
I would like, when you have your additional conversation, to clarify this for me, because I was in a work group and I thought the prosecutors explained to us that the crimes, misdemeanors that this would be added to were, the through line was some aspect of it taking time and more than a year sometimes for the discovery or the full extent of this crime having been committed. So that got me to the point of, then this makes sense. So if I misheard that and that is not the through line, then I would like to know more about that. So that would be helpful.
No, that is exactly it. And I was talking about for the other misdemeanors that have no statutes of limitations. They're just like,
That's the group I'm talking about. And I thought
Yeah.
they said to me, we were adding it to a statute that had a lot of misdemeanors that had no statute of limitations. And the reason they were in that category was the same as what was being put forth on this bill, which is the nature of these crimes can often do, not always, but can and often do, not fully understood or discovered by the victim and law enforcement until well after the year. But if that's not what I understand, if I'm wrong about that, then I'd like to know that I didn't hear them properly. Thank you.
I get it to the three misdemeanors here, and I know that they didn't want to make them felonies for that purpose,
Right.
or there was discussion about that, but I got to tell you, I'm looking at this stuff and I maybe I'm wrong. I mean, some of this stuff doesn't fit that, but the three that are mentioned here maybe do fit that. And that's why I was thinking.
I remember them, sorry.
Yeah, no, that's what I was thinking, like almost doing, and that's why I have one more person to talk to, and I'm
not
almost
telling you
there.
I'm right.
Yeah,
I'm
yeah.
telling you, they went through some of those
Yeah.
crimes and showed me even ones that I didn't think were a problem or why they needed more time, and they explained it to me, but I may not have remembered it. So anyway, just educate me, Mr. Chairman, when you get more
No,
information.
I need more education because I didn't have that direct discussion. I
Okay.
just got the list.
Got it.
And that's why initially I was thinking like you do like maybe graduated like 5 years for this
Right.
or 10 years, but
Right.
yeah. So, yeah, but they have the discussions, could take longer than it. So we'll see how it goes. Senator Kelly.
I wanted to loop back to Senator James's point, because I was in that work group too, and I have the memo that they sent us, and it does say sort of the through line is that thematically these cases these are cases that take time to appear. So you are correct. That is the case that they were making, and they went through with why these are the crimes that don't have a statute, or misdemeanors that don't have a statute of limitations. So you were correct about that, but thank you
No, that's
for your
good.
point, Mr. Chair.
That's good. All right. So we'll come back. For me personally, I appreciate the committee's indulgence on that. It is a good bill. We're definitely going to get there, but it's one person talking. Okay. We'll now move on to Senate Bill 413.
Senate Bill 413 prohibits discrimination based on military status with regard to public accommodation, housing, employment, financial transactions, education, insurance, the provision of public utility services, and state personnel actions. There are no amendments.
Motion for favorable and seconded. Actually, I'd like to be added on as a sponsor if I'm not already. Senator Charles, Senator Folden, Senator James, Senator West, Senator Smith, Senator McKay,
Is there anybody that doesn't want to be added on?
Senator Muse.
You want to be on? Does anybody not want to be on?
Yeah.
Yeah.
That's fine. So that's fine. Okay, so got those sponsor amendments, and then is everyone okay with that sponsor amendment being adopted? Now the bills before you as amended, motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. So we have one no, and so the bill passes 10-1 as amended. Okay, excellent. All right, we'll now go. So Senate Bills 470 and 471. We're still waiting for amendments from the departments. So we're going to hold both of those. And we're going to go on to Senate Bill 501.
Senate Bill 501 requires the Secretary of State Police by October 1st, 2024, and annually thereafter to publish and make copies available to the public a handbook summarizing the state laws that apply to the wearing, carrying, and transporting of a handgun in public in the state. There is an amendment in your voting packet for Senate Bill 501. It is Amendment 433-624/1. That's Amendment 433-624/1. This is from Senator McKay. The amendment conforms the bill to the House version, which is similar to Senate Bill 501, but requires the Secretary to develop the handbook in consultation with the Office of the Attorney General, that the handbook be drafted in plain language that can be easily understood without any special knowledge of the laws of the state, that the handbook be published in both print and electronic form, and that the Secretary provide notice of updates to handgun permit holders.
So motions to move the amendment. That's okay with me.
It's 120, so we're still
Still good.
threshold.
Okay. Now the bills before you as amended. Further discussion? Motions for favorable been seconded. Do we need a roll call? Or are we good? Is everyone okay being reported in the affirmative? All right, everyone's being affirmative. We'll now move on to Senate Bill 521. So sorry, Senate Bill 501 as amended passes unanimously. Senate Bill 521.
Senate Bill 521 alters the salary of the sheriff of Garrett County and it repeals the requirement for the Garrett County Salary Study Commission to study and issue a report that contains recommendations relating to the salary of the sheriff.
Motions for favorable and seconded. Is everyone okay with being recorded in the affirmative? All right. Conversations with yourself. There you go. Senate Bill 521 passes unanimously after vigorous debate and discussion from the Garrett County delegation. We'll now move on to Senate Bill 585.
Senate Bill 585 requires the operator of a vessel involved in a collision, accident, or other casualty that results in bodily injury to or death of another person to stop the vessel as close as possible to and return to and remain at the scene of an accident until the operator renders assistance and provides information which is specified in the bill. The bill establishes criminal penalties for failure to comply with these requirements and establishes a specific penalty for failure to comply with the existing duty to render aid and provide identifying information at boating accidents. The new bill's requirements for stopping is close, or excuse me, the new language requirements for stopping is close to the scene and returning to and remaining at the scene of an accident are similar to requirements that pertain to motor vehicle accidents under existing law, and the new graduated penalty provisions of the bill are generally identical to graduated penalty provisions applicable to motor vehicle accidents. There are no amendments.
Are there special considerations for remaining on the scene in littoral situations, counsel? That's actually a serious question.
I suppose it's different if you're, close to the shore, right? But I guess if you're in the middle of the Chesapeake Bay, I don't know. In a shipping lane.
Senator West.
I'm just like there's a definition here entitled serious bodily injury, but the term bodily injury without the adjective serious is in both A1 it appears twice in the first two paragraphs of the bill. So shouldn't we add the adjective serious?
So it's actually interesting. That language is what's found in the existing transportation law article. There are graduated prohibitions and penalties related to hit and run. So sort of at the lowest rung, and I'll just walk through the transportation article provisions that already exist. At the lowest run, failing to stop close to a scene or return or remain at a scene is an offense on its own, and it carries 1 year, $3,000. Then there is death occurs and failing to stop or return to the scene. That's 5 years, $5,000. Then there's a specific provision in transportation that is a violation where there is serious bodily injury and the driver knew or reasonably should know that serious bodily injury would result. So they do actually use serious bodily injury in the transportation article, but I think your question was
In this bill.
in that bill,
it's a
in the
defined
lead-in
term.
language, it's different. And I think Senator Fulton may have a more direct answer than what I have, but I'll defer to you, Mr. Chair.
Thank you. So the transportation article portion of the serious bodily injury component, it also is an integral part of hit and runs, but also of DUIs or driving impaired. So that is one of the necessary elements to be able to require a blood draw should there be impairment or refusal to take a breath test. So that's where in that it requires, if you're involved in a vehicle collision that results in serious bodily injury or death, that you can no longer refuse to submit to a requested breath test.
Senator West, if I can follow up directly to your question about early at the top of the bill, it says bodily injury, but it lower it has a prohibition related to serious bodily injury. In the transportation article, so 20-102 A1 provides that a driver of each vehicle involved in an accident that results in just bodily injury to another person, so it doesn't need to be serious, shall immediately stop the vehicle as close as possible to the scene of the accident without obstructing traffic more than necessary. And that's the I guess prohibition that I was talking about with the 1 year, $3,000. So for that low tier hit and run, it doesn't need to be serious bodily injury if it's in a motor vehicle either. It just needs to have caused some bodily injury.
Here's my thought. So I'm out in a boat and I make a mistake and it grazes another boat, and one of the passengers on the other boat falls over and has a slight abrasion cut on her leg. Am I by this going to be required to anchor my boat near the scene of the accident for a period of time?
Well,
if she says there's no problem, don't worry about it. That's a bodily injury, but it's not a serious bodily injury. Why
right.
should I have to hang around out in the middle of the bay?
And the requirement is, well, I mean, just as the requirement is, if it were a motor vehicle, and you had a collision with them, and it resulted in some injury, you would still be required to stop for that. Or no injury, because that involves just damage to property, correct?
Excuse that again.
Or no injury, if it involves property damage, you still have a requirement under the law to stand by and at a minimum exchange information or summons police.
Okay.
This is just closing the loop of a vacancy in the law that doesn't allow them to charge with hit and run in the waterways.
No, I get it.
That's all this is.
All right, this is a motion for a favorable. It's been seconded. Is everyone okay with being recorded in the affirmative? All right. Senate Bill 585 passes unanimously. Now move on to the last bill of the day. Senate Bill 658. Motion for favorable, let's hear it for the record, though, just, I know, we're almost there.
Senate Bill 658 alters the salary of the Anne Arundel County Sheriff to be equal to the salary of a captain in the Anne Arundel County Police Department at step 20 in the pay scale. Pursuant to constitutional requirements, the salary structure specified in the bill takes effect at the beginning of the next term of office. There is a delegation letter in your packet.
All right, motions for favorable to seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 658 passes unanimously. That's the end of our voting session. Have a good night.